I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. If there are two defaults that are in a lot of lease forms and are very unpopular with the lessee, they're material adverse change and lessor deems itself insecure. These defaults are probably the first two that experienced counsel is going to cut out. Consider this. How likely are you ever to actually call a default because there's a material adverse change or because you deem yourself insecure? Sometimes the better path is to go ahead and negotiate those provisions out, but replace them with something that is more specific. For example, what constitutes a material adverse change? We've got cases that have come up mostly in the merger and acquisition area in which judges have said material means it is something that if you knew about, you wouldn't have done the financing in the first place. We're not just talking about something that could be a problem in the future. So, change of management, change of business, change in format of business, which should be a default anyway because it affects your UCC filings. This kind of thing can substitute for a material adverse change. It may be more acceptable to the lessee because the lessee can understand what its risks are. At the same time, it may be more enforceable, and it may be something that you are more likely to take a second look at the deal over. The deemed insecurity is a particular problem. At least a reasonably deem itself insecure is a provision that some lessees are willing to accept. However, that creates an objective standard, and some courts, even if the language reasonably isn't in there, are going to apply a reasonable man standard in interpreting that language. Again, we feel that it's probably better to be a little more specific and actually have a circumstance. This means, in some cases, putting financial covenants into your lease or negotiating them as to particular lessees. A lot of leasing lawyers don't have familiarity with financial covenants. Most banking lawyers do. Financial covenants are never the type of thing that you can simply say, I have a debt service coverage ratio, and expect every lawyer to write the same thing or every credit offer to understand it is the same thing. Each one must be specifically tailored to the circumstance, the lessee and its credit, and in some cases to the business of the lessee and the equipment that is involved. These changes are more likely to make your default section enforceable, and they are also more likely to be acceptable to your lessee than any material adverse change or we deem ourselves to be insecure. For this and other information, visit us at www.leaselawyer.com.